The nationwide vacatur and block of the ATF's pistol brace and SBR rule is now being impacted by the new Trump executive order to protect the Second Amendment. So let's talk about what is happening. Now, real quick before we jump into this video, I want to ask you guys for a favor. Looking at some of my analytics, about 58 to 60% of all viewers are not subscribed. So if you want to support the channel for free, please consider subscribing. By no means are you required to, but it does help the channel. And then also just drop a positive comment down below and share this video, because that helps to tell the algorithm that you enjoy this content and it should share it to more people. As I mentioned in the intro, we have some important news in the battle against the ATF and their current restrictions on all braced pistols as SBRs. Currently, there is a nationwide vacatur on the pistol brace rule, and there are also multiple preliminary injunctions which are protecting various 2A organizations, companies, and members. However, now with the new administration in power, in the recent Trump executive order on the Second Amendment, there have been some very important changes that are now happening in these critical lawsuits. Now, the mock lawsuit is one of the most important challenges we have going on right now against the pistol brace rule, because currently there is a nationwide vacatur that was issued by the lower court judge that is blocking that rule nationwide. Now, currently, the Trump administration notified the Fifth Circuit that they wanted to hold the pending decision and review in the Fifth Circuit, essentially so the new administration can determine how they want to proceed forward in this lawsuit. Well, the Fifth Circuit just granted the Trump administration's request to hold the pistol brace challenge in abeyance for a temporary period of time. So we need to talk about what is now going to happen in this challenge and what's going to happen with the pistol brace rule. Now, you may recall that after the ATF suffered multiple losses in a variety of pistol brace cases, they decided to appeal up to the Fifth Circuit Court of Appeals. Not only do we have multiple preliminary injunctions that were granted against that rule by various courts, various judges in multiple different cases, but recently you had Judge O'Connor who issued a final merits decision in the mock lawsuit, and that struck down the rule completely nationwide on a final merits. In his decision, Judge O'Connor stated that at the conclusion of the majority's careful analysis, they held that the final rule is properly characterized as a legislative rule, and it is relatively straightforward that the final rule was not a logical outgrowth of the proposed rule. Therefore, the final rule must be set aside as unlawful or otherwise remanded for appropriate remediation. Now, that decision was huge because it was a final merits decision which struck down the pistol brace rule entirely based on the Administrative Procedures Act. One of the main things in that decision was talking about the logical outgrowth test, and it discussed how the proposed rule had that worksheet 4999, which kind of had a report card system and a point system that you would add up to determine if your brace pistol was an SBR. Well, when they finalized the actual pistol brace rule, they didn't have that report card system in there. Instead, they had some vague language in some of the principles that maybe were included in the report card system, but the report card system was pretty much scrapped and was not in the final rule. And the judge here found that that was improper under the APA, and so he struck down the rule based on the APA. Now, in response to that decision, the ATF then appealed up to the Fifth Circuit. Currently, all the briefs have been submitted to the Fifth Circuit in that mock case, and we're waiting for oral arguments. There were also some very interesting developments that happened at the end of the Biden administration, and you had some interactions where the ATF seemed to take the position to an individual who sent them an email that despite the rule currently being blocked nationwide by Judge O'Connor, the ATF still believed that they could potentially enforce the brace rule and the whole theories in the brace rule based purely on the statutory text. But now a lot of that is changing because the Trump administration has issued the executive order, has control, and also notified the Fifth Circuit that they want to hold review in this case until they finalize what they want to do through that executive order. The notice filed by the AG's office to the Fifth Circuit states that following a change in administration, on February 7, 2025, President Trump issued an executive order titled Protecting Second Amendment Rights. Among other things in the order, it directs the Attorney General to examine various actions of executive departments and agencies to assess any ongoing infringements on the Second Amendment rights of our citizens and present a proposed plan of action to the President through the Domestic Policy Advisory to protect the Second Amendment rights of all Americans. And the order specifically directs the Attorney General, as part of that process, to review all rules promulgated by the Department of Justice, including the ATF, from January 2021 through January 2025, pertaining to the firearms and/or federal firearms licenses. In light of that development, the government respectfully moves to hold this case in abeyance for 60 days pending review of the challenged rule. So the Trump administration is going to target the ATF's regulations through the new executive order, and that would include things like the pistol brace rule. They have notified the Fifth Circuit that they want to potentially delay review of this case and the oral arguments so that the administration can determine what they want to do going forward and potentially also how they want to handle this lawsuit. Well, the Fifth Circuit just responded to that request, and they granted the request to hold the pistol brace case in abeyance. The order of the Fifth Circuit states that it is so ordered that appellant's unopposed motion to stay is granted as stated herein. The appeal is obeyed until April 14th, 2025, at which point the abeyance shall automatically dissolve. Appellants are permitted to file a status report as stated in their motion. So with Trump and his administration now taking over and issuing that executive order, there are some very interesting options that are now on the table. One of the things that they're doing is kind of holding a lot of these cases to determine generally as a policy what they want to do with some of these ATF regulations. The Fifth Circuit has given them until April 14th to determine what they want to do, not just with the pistol brace case, but also they're going to be reviewing a lot of the other things that the ATF has put in place. Now, also very interesting, at the beginning of this week, the House Judiciary Committee through Jamie Raskin sent a letter to Pam Bondi expressing concerns about the upcoming report, along with asking her to respond to a variety of the questions that they have, and they want a response by March 17th. Some of those questions include things like what standard will you use to determine if any order, regulation, guidance, plan, or an international agreement or other actions violate the Second Amendment. They also ask things like, how will you ensure that your plan of action does not increase violent crime within the nation? They also ask for clarification on when the plan will be announced and exactly kind of the game plan for how it will be implemented as well. They want an answer on that. Now, one of the main concerns in the letter from this committee and Jamie Raskin's is they have concerns that the Trump administration will be rescinding the zero tolerance policy that the ATF put in place, and how they've been rescinding FFLs and going after FFLs for minor issues and paperwork. And really what the letter indicates is how concerned some of the liberal Congress members are about the executive order and the rollback of a lot of this ATF overreach. And they've also been even more concerned because now you have Kash Patel, who is not just the director of the FBI, but now he is the acting director of the ATF. And I can tell you from my personal experience, I got to spend a little bit of time with Kash Patel actually before, he was an FBI director, before he was the new director of the ATF. I got to spend some time with him along with GOA and a lot of other creators. We got to have dinner with him, have conversations with him. I personally got to have some conversations with him. And I can tell you from just the small amount of time that I spent with him, he is very pro Second Amendment. He, has spent time with organizations like GOA. He understands the issues. He's got to speak at, the GOA's convention on the Second Amendment. There are plenty of things out there where he's talked about his stance on the Second Amendment. So I think we're in good hands with him currently kind of as the acting director of the ATF. And I believe that he, along with the Trump administration, understands these issues, and they're going to be attacking these ATF regulations and rolling them back. So the pistol brace lawsuit has been held in abeyance for a temporary period of time until April. But the positive thing along with that, if you have a question about, the current legality of pistol braces, the nationwide vacatur issued by Judge O'Connor is still in place. It's going to remain in place, and really is probably going to remain in place at least until either the Fifth Circuit rules in this case or until the Trump administration takes some sort of action on the rule. So that's what's currently going on with the pistol brace ban and the impact of brace pistols being treated as SBRs. The nationwide vacatur is still in place. The important lawsuits have been held in abeyance, and the ATF and Pam Bondi are probably going to be taking actions on the pistol brace rule. I think that they're probably going to rescind it. I would like to see this play out in the courtrooms so that we can get some actual strong precedent in the Fifth Circuit and other circuit courts against this type of action. But they're going to determine how they actually want to do this. Do they want to proceed forward in the lawsuits? But I think the easy thing that they're going to do, and maybe the easy win that they want, is to just rescind some of these orders. But we'll see how that plays out once Pam Bondi issues that report to President Trump under the executive order. So that's what's going on. If you have any questions, go ahead and comment down below, and I will try to answer to the best of my ability. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe, And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.